Today's talk is sharing a part of the research. It's a larger project on navigating forums and actors in the field of family law concerning marriage breakdown. And I start with the concept of access to justice and move it over to the complexities of access to justice in family law when it concerns ethnic minorities. So, what we've learned from Rod MacDonald is that, while in a well-functioning liberal democracy requires the legitimacy of democratic processes to be founded on a commitment to equal access to and equal justice in public and private institutions of governance, we see that while lawmakers proclaim the importance of access to justice, what they really mean is access to law. And I take issue with this specifically in this work, and I want to interrogate how we understand justice, especially in the context of marriage breakdown. And so when we think about access to justice, it's both evocative yet double-edged. We need to, as lawmakers and policymakers and thinkers and academics, we need to rethink the attitudes and expectations about who owns law, about what it can realistically accomplish, and about how it can most effectively be deployed to promote a more just society. So I take this to the issue of my work, which is to present two cases that I've looked at in my larger legal ethnography on Punjabi Sikhs. The site of study is marriage breakdown, which I look at as a spectrum rather than as just divorce, because people exist in so many different situations of marriage and its breakdown. But also that studying one particular social formation, Punjabi Sikhs, is a really interesting look at a different minority group in the Canadian context. I use the term Punjabi and Sikh together because there's an ethnic component which also relies on customary law, as well as a religious component which also has its own customs and precepts that have some relevance in the concept of, or the conversation about marriage breakdown. The other really interesting feature about the subjects of study are the transnational roots and transnational connections that continue to form and evolve this very large diaspora community. So though they're not a large population from the Indian subcontinent, they have a very large diaspora community across the world. And so these networks of kinship sort of facilitate not only marriage, but also many other life processes. And I find that super interesting when we consider customary law and its sort of migration to the Canadian context. So, but while Punjabi Sikhs make a significant portion of the South Asians in Canada, very little is known about this minority population and how they might access legal needs. So this paper argues that despite reforms made since 2009 to Ontario's civil justice system, particularly in the area of family law to enhance access to justice, a critical analysis of two cases I'll share with you. The first is Graywell versus Kaur, and the second one is Sidhu versus Chahal. Exposes certain disjunctions between official law actors and the lay people who come before the court. Now, this is only one aspect of the work. The other aspect of the work looks outside of legal forums to see how Punjabi Sikhs might seek justice in unofficial contexts, meaning in community context, in the context of kinship, in the context of religious institutions, etc. And it's the first, to my knowledge, of this kind of work in Canada. Most of the work is on Muslims or Jewish minority populations. So I'm trying to push that boundary there. So let's move on. I just need to give you a little background on where I'm coming from with respect to family law. As a result of its shared jurisdiction, Canadian family law has really interesting characteristics that make it different from other international or national jurisdictions. But it also has a really interesting relationship to the Charter. So as we saw through the development of women's rights movement in the 70s and 80s, there was an expansion of certain legal rights that have made Canada quite a leader when it comes to women's legal rights and entitlements. And these were sort of enshrined in charter values as well. And we've seen that this actually raises interesting questions when it comes to family law, because family law is traditionally known as a private realm of law, but through the advances in charter rights, we see this sort of uncomfortable relationship between public and private characteristics of family law. Now, I think this is the most interesting part when it comes to minorities, because when we're thinking about how the family operates and the types of needs families have as they go through marriage breakdown, it really does bring up larger issues about the role of public values in private settings. The doctrine of formal equality embedded in the Charter has pervasive implications for family law arguments, judicial decisions, statutory reform, as well as family ideology. And what I find really interesting is Marion Boyd's report, which she rolled out after the Sharia law debates, clarifies that the rights paradigm based on the autonomous individual and the application of formal equality and due process does not easily apply in the family law context, since individual family members are encumbered with complex interdependencies, needs, and relations of care. But the politicization of the family, as we've seen in various Western jurisdictions, in the UK, in the US, in Canada, have meant that it has become even more of a battleground for certain values and the assertion of certain rights, and the explicit denial of others. So what I want to do is just move on to what this means in the Ontario context. So a 2011 report identifies women as the most likely to experience a civil legal problem, most likely to report family relationship problems as their reason, yet women represent the group least likely to seek legal assistance. This disjunction is exacerbated for any ethnic minority group, which face these hurdles in more accentuated forms. In 2009, the Ministry of the Attorney General rolled out extensive reforms which unified family courts in 17 different districts. There's a range of ADR processes that have been included in that strategic plan. But what's really interesting is that that plan has no reference to religious arbitration, which anyone from Ontario would know that from 2003 to 2006, we had a very large and heated debate about Sharia law having any presence in our legal system. Now, what I think is really interesting about that, while I'm not talking about Muslims, is that it has sort of created the context in which other minority groups have now entered. And so whatever claims they're making is in the backdrop of this very large and sensationalized conversation across the country and also across the world. When I was studying in the UK, they always would ask me about the Sharia law debate. And I think that what we see is the Ontario family courts are mandated to encourage and strengthen the role of family through the recognition of the equal position of spouses as individuals within marriage. But the interconnected kinship orientation embedded in Punjabi and also more generally in South Asian law and society indicates there are relevant gendered ramifications to this legal commitment. So I'm going to bring up this first case, jump right in, so I don't miss out on any detail. This case took place in the Brampton Courthouse. It involves the two parties, Graywell versus Kaur. Graywell is a Canadian citizen, Kaur is not. She's from Punjab, from India. And Madam Justice Van Rensburg presided over the case. Graywell sought an annulment and Kaur sought a divorce. They had an exchange marriage, which involves two different parties marrying each other's based on gender. So a brother and a sister married a brother and a sister in two different jurisdictions. Now, this is a kind of frowned upon practice, but it isn't uncommon. But it is part of this transnational character that we see of Punjabi Sikhs. So the Canadian aunts of both parties arranged this marriage. They were eager to assist their Punjabi nieces to immigrate to Canada and had an adopted son of marriageable age. So they met through a newspaper a Canadian newspaper, set up this alliance, went to India, had the marriages, came back, did all the sponsorship, and the first sponsorship, which was for Kaur, came through. She immediately flew to Canada. As soon as she arrived in Toronto, which is where they resided, she then flew to Vancouver, which is where her aunt, who arranged her marriage, and her brother, who was involved in the second marriage, lived. Now, the court deemed that this action itself meant that she was insincere in her intention to marry, and had then decided that she was in the wrong. So there's a lot of detail to this that I'd love to go into, but for the sake of making the argument, what I'll just say is that there's a lot of interesting features about this case that show the complex exchange between official law actors and Punjabi Sikh disputants. Firstly, this was an exchange marriage. Though it's not reproachable, it wasn't traditionally arranged. So most marriages from the Indian subcontinent are arranged marriages, which mean that they come with certain security and background checks that were missing in this marriage. So the female spouse becomes more isolated and exposed in cases of marriage breakdown. Now, the second feature of this is that while consent of both parties was obtained, the court recognized that the intention of the marriage was not primarily organized through romantic affect. Rather, actually, the thing is that Graywell had been married 3 times before this, and Kaur didn't know. Kaur didn't know any of this. And so, according to Punjabi traditional norms, this marriage would never happen. She was a university-educated woman from India. He was a retail salesperson in Canada with a high school degree. So certain kind of characteristics show us that this wasn't actually a match made for the right reasons, rather it had a different intention. So it follows then that there were certain deceptions made by Graywell, and there were other factors, including immigration, that informed her consent. In fact, Graywell's aunt explained to the court, quote, "This marriage would help both families, as Graywell's sister and Kaur could then sponsor other family members to immigrate to Canada." Now, as you might know, when you adopt someone, you can no longer sponsor any of their family to Canada. So this marriage arrangement was a way to facilitate chain migration, which is an essential part of the Punjabi sort of global diaspora norms. Now, plausible actions for Kaur's flight to Vancouver immediately after landing might include that she wanted to reconcile the hidden fact that Graywell had a history of 2 failed marriages. Sorry, not 3, it was 2. And that she found out that there was a dubious history of failed attempts to bring Graywell's sister, who was involved in the marriage with her brother, also to Canada. So she had all these questions about the second arrangement. And her brother had then pulled back from the arrangement and said he didn't want to do it anymore. So she went to Vancouver to go and persuade him. And also, she tried to do some form of informal mediation with her brother and her aunt to make her marriage a success. Nevertheless, the power imbalances inherent in marriage migration ultimately discredited her account, and the oft-repeated and strategic use of the sole purpose of immigration or primary purpose argument was an apt reference. So, finally and most critically, I don't actually have time to go into Sidhu versus Chahal, but what I will say about this case is that the most interesting feature about it was how the justice ruled on this case. And so whether annulment or divorce applied, the justice ruled that while Indian family law might have allowed an annulment in a much wider range of circumstances than Ontario family law, she expressed concern applying foreign law affecting marital status outside of its cultural context, end quote. Especially when they are, quote, inconsistent with fundamental Canadian values, end quote. Now, Justice Van Rensburg's remarks are noted in light of ongoing European conversations about the presence and informal and formal operation of minority legal orders, which I had the pleasure of getting involved with when I was at SOAS. Her remarks indicate a deeper discomfort amongst official law actors in Ontario with the complexities of adjudicating minority family law matters in an increasingly diverse society. Now, what I will do is move past, oh, there's the quote. Move past Sidhu, which is a really interesting case about two university students at York who fell in love and got a civil marriage without knowing they were getting a civil marriage, and then asked for an annulment because it would be shameful to be a divorced person in the community. So moving over to analysis, I'm really interested in how we understand multiculturalism in the realm of family law. So while we understand that multiculturalism is the coexistence within the same political society of a number of sizable cultural groups wishing and in principle able to maintain their distinct identity, we have spent much less time in the legal realm understanding what the implications are. So, but the issues, as the Sharia law debates have highlighted, about women's rights, about protecting women from dangerous men, which is incredibly couched in a racist rhetoric, needs to be further discussed, I think. While we have made peace with that debate and we've moved past it, the implications are still being felt when we look at other minority groups. As signaled by Madam Justice Van Rensburg, Ontario justices presiding over family law cases may be discomforted in dealing with ethnic minority, cultural, and/or religious issues. And Marion Boyd's report notes that there is an apparent cultural anxiety in Ontario associated with entering the religious thicket, a place that courts cannot safely enter into and should not go into. And so I tie the Graywell versus Kaur case to Sidhu versus Chahal because there's a really interesting judgment from there that I'll just put here. So the cross-referencing is really interesting, but also that there's a limitation on how we might accommodate minorities who are not understood. So this idea of honor that was central to some of the arguments that I saw in my cases is something that has no value in the legal system because it's not understood as the same as perhaps a talaq or a get or any other particular religious observance from another minority group. So what we see instead is that there's a lack of space or time or comprehension with respect to issues brought forward by other minority groups. The remarks of this justice signal that a number of issues remain at a fundamental level with respect to making family justice accessible to ethnic minorities. Thank you.